Hello everyone, my name is Aarti and you're watching HW News. The Supreme Court of India is the apex institution to deliver justice. The orders passed by the Supreme Court are also binding on everyone, yet there are certain exceptions. But by and large, in a country where rule of law is held supreme, the orders of the Supreme Court are also followed religiously. Their decisions are accepted and implemented. However, in recent times, we have seen civic authorities completely disregarding the order of the Supreme Court, so much so that the Supreme Court had to step in twice to put a stay on the authorities' action. This blatant violation of Supreme Court order happened on live camera. The court, when it took up the matter for hearing, was clearly not happy with it. Now, in another matter, the Supreme Court has issued a stern warning to the official of the Home Ministry of India. The Supreme Court took objection to the words used in the centre's reply to Gangster Abu Salem's plea. In a stern warning, the apex court told the Home Secretary to not lecture the judiciary and not to tell it what to do. We do not take it kindly when you tell us to decide something which you have to decide. This is what Justice SK Kaul said. He slammed the government while hearing the matter. What is the issue and why was the judge angry at the government? Let us discuss in today's video. Justice Sanjay Kishan Kaul and M.M. Sundaresh were hearing a petition by Abu Salem, a convict in the 1993 Bombay blast case. What India had guaranteed to Portugal courts that his jail sentence cannot exceed 25 years. Salem was detained on 18th of September 2002 by the Portuguese authorities on account of a lookout notice. In 2005, he was deported to India. While extraditing him, the then Deputy Prime Minister, Mr. L.K. Advani, on behalf of the Government of India, had given an undertaking of assurance to the Government of Portugal that it will exercise its powers to ensure that once extradited, Abu Salem would not be visited by death penalty or imprisonment for a term beyond 25 years. Abu Salem's counsel argued that the counting date of 25 years should start from the date of his detention, but the Indian government argues that it should be counted from the year of his deportation. On Abu Salem's plea, the Supreme Court had asked for a reply from the Home Ministry. However, the apex court was particularly irked by the stand taken by the Union Ministry of Home Affairs that it is not the appropriate time to decide the issue relating to the sovereign commitment made to Portugal while extraditing Abu Salem. The Supreme Court also expressed that it did not appreciate the tenor of the affidavit filed by Union Home Secretary. The bench noted in its order that the MHA seemed to suggest what the court should do or should not do with respect to the case. The bench said, and I quote, "It is stated that this honourable court may decide the appeal on merit. As to what this court has to do or not to do is for the court to take a call on. We don't appreciate the tenor of the affidavit. If a convict seeks to accept his guilt and conviction, it cannot be said that the court must hear the appeal on merits." Now, the bench was particularly also disappointed with the following extract from the MHA affidavit. The affidavit goes like this: that having carefully examined the matter and the ramification which stand of Union of India will have, it is the respectful submission of the central government that this honourable court may decide the appeal on merits. The compliance of the assurance dated 17th of December 2002 will be done at an appropriate time, and the Government of India will abide by the assurance in accordance with the law and subject to the remedies as may be available at the stage. Now, the bench also took exception to the MHA's stand that Abu Salem's plea was premature and that he can raise his plea only after 25 years. It said, "We have to take a call on the effect of the assurance and we cannot postpone the hearing of the appeal on that basis. Nor is it permissible for the government to say on affidavit that the appellant cannot raise this plea." This is what the bench said in its order. The court also added that Salem's plea is neither premature nor based on hypothetical surmises. Justice Kaul referred to certain portions of the affidavit that he thought were also evasive. "You say that the commitment would be abided with at an appropriate time. We asked you. You had to answer. There was no requirement for your Home Secretary to lecture us. The right is available today. How can he say that there is no question of the convict arguing based upon the assurances given? He also slammed the government for not taking a firm stand on the issue. So this is what transpired in the Supreme Court. Do let us know what do you think about this in the comment box below. For more news and updates, you can log on to www.hwnews.in.